So, we're good to go? Okay. Right, welcome to Karen. As I say, another name that will be known to many of you. Karen is, I'm grateful for the stepping word took a short notice, actually, she's still in the speaker slot. So, thank you very much. And she's going to talk about a subject of key importance to the surveyor firm fraternity, which is a surveyor's duty of care. One of our small craft members wrote to me about 6 months ago about a problem, not a problem, but a potential problem of evaluation. And it was where that legal wrangling sort of developed. And in the end, it became a rather unpleasant court case that cost the surveyor quite a lot of money. He was insured, and the insured paid up. But I got in touch with Karen. I said, can we expand that? And Karen has got some case histories, some case studies. And I think it'll be a fascinating presentation. I should also say that Karen is a director of Matrix Insurance Services Limited, as well as having a detailed knowledge of the insurance sector. Karen is also a non-practicing lawyer. And I know you caveat all of that with various disclaimers and things. I said to her earlier, I said, thank you for this, just a disclaimer. She writes regularly for the Report magazine, if you didn't know that, and her very risque series entitled 50 Shades of Insurance now spans, I don't know how many editions, but
14. I mean, it's Shades of Law.
Shades of Law. So without further ado, the next 45 minutes is yours.
Right, thank you very much, Mike. Thank you. Thank you for inviting me again to talk. I'm going to adapt the presentation slightly where I can because there's people from various jurisdictions here, but it was originally written for the UK and obviously for the insurance market here as well, and when you're dealing with people in the UK. I've taken a very light-hearted look at this subject, which is quite complex and baffling in many respects. When you think that as lawyers, we spend a whole year learning this subject, at least a whole year learning this subject, and that's just the basis. For people to just come in and understand, I don't think that's possible for all the elements, but the basis, I think, is quite important. Once you grasp the basis, then you know when to question whether you've got a problem or potential problem. So, right. Is that correct? Little interlude, yeah. Whilst we're waiting, if anybody wants to have a fan and hasn't picked one up, it goes on your phone or on a stick. So please feel free. Anyway, I wrote this for the article in the Next magazine if you want to read it. And it's an adaptation, obviously, it's the Eeyore wrote it there. If you remember that from childhood. And it was really a thought from talking to people that I have to deal with, whether I'm undertaking the insurance side, i.e. insurance broking side, when we place insurance for professional indemnity, and I have to deal with claims, it's always difficult to try and explain to people that, that there is no sort of immunity, and this is one of the problems, and then trying to explain the duty of care, particularly at what tends to be quite an emotional time when you're undertaking what could be a potentially a claim. So this is why there's quite a light-hearted view of the topic. There we are. So this is something which really just emulates the bewilderment of people when they talk about duty of care. And quite frequently, it's very difficult for people to understand where it comes from. And some of it is common law and some of it is contract. So that's just my general slide to ask if you want to wait to ask questions. Or if you feel free, if you do want to ask a specific question, if I can answer it, then I will do so. Right, I have spoken to talk about acoustics and claims, and obviously Winnie the Pooh is the sort of the theme here, as you might well guess. And I did hope it might sort of wake people up after lunch, because I'm sure you're all feeling slightly tired after a lovely lunch. And the reason why I think it is quite important to actually emphasise this, although the top part is obviously with a sense of humour, is the fact that you really don't know when you start your claim And they don't know when you start your claim, that's when you start your defence, what the outcome is going to be, because the outcome is really down to the facts and how good, obviously, your lawyers are or whoever's dealing with your claim. So really, it is just like dropping the sticks in and see who's winning. So you've got your claimant and your defendants, and when they come out the other side, and by the time you've gone through the whole process, which is passing under the bridge, you've got all your facts and everything, and by this time, often the costs are so high that you get to the stage where everybody decides to carry on. And this is one of the problems with claims generally. I have previously talked about mediation, which I'm not going to go into in this talk, but that's one of the reasons for using a form of mediation, is to try and cut down the costs. Anyway, immunity. Many, I wouldn't say many actually, now I carry that. A number of people have said, oh well, isn't there immunity for professionals? The courts in England in particular, and Scotland follows, and other countries do, particularly part of the Commonwealth, is the fact that immunity has gradually been removed by the courts for all professionals. It doesn't matter whether you're lawyers, engineers, generally across the board, they've removed immunity. And this is quite important because it's a more recent decision where the courts have now decided that there's no protection for expert witnesses. This is obviously more important also with defamation, and there are other areas which you should consider when you're talking, and particularly when you're writing as well, because be careful. I see a lot of times when comments are made because they think there's only going to be one reader, but there is no immunity, and also the release of reports. If by chance somebody happens to mention that you've written a report and then it has to be released, then you put something into it that could obviously be a cause of action. By that I mean could be a basis for starting litigation. Just be wary of how you phrase things in your report. Always think about the fact that you need to look after yourself as well and make sure that somebody can't claim defamation, because that has been undertaken if you want to look at case law. And it's not just in the UK, because I said others follow it as well, because we also follow, for example, cases in Australia, as well as obviously Canada, and they follow us again. A lot of the Commonwealth countries follow each other and look at the judgments. So be careful of the changes that are going on. Right. Now we're looking at why do surveyors have a duty of care, and again I have used this from the English law perspective, which I said is carried through other jurisdictions. But it's based really on this case of Headley Burn, and I think it's important that you understand that it's easy to get caught out, particularly if you're talking in what you think is a casual way. And some of the largest claims that I've dealt with have emanated from people being helpful. And the one rule when I was taught as a lawyer, which you'll see at the end, is don't give advice as a favour, okay? Because it comes back and bites you. Because if they can prove reliance, which I'm going to read just some information out from the general textbook so you understand, then you could find yourself in trouble even though you've not been paid. And also the worst thing is, if it's not a paid job, the question is whether you've got insurance cover. So always bear that in mind, because normally a lot of insurers will require it, but that you're actually undertaking it in your professional capacity. So be aware of that. You can find that you actually have no insurance cover for it. So just to give you a little bit of background with Headley Burn, I'm just going to read from a textbook. The appellants were advertising agents who became doubtful about the financial position of one of their clients, E Limited. The appellant's bankers inquired from E Limited's bankers, the respondents, as to the financial position of E Limited. The defendants replied that E Limited was a respectable, constituted company considered good for its ordinary business engagements. The advice was given without responsibility by the respondents. Now that's important, that affected the case. If they hadn't given the advice without responsibility for the respondents, the outcome would have been different. Relying on this advice, the appellants lost over 17,000 when E-Limited went into liquidation. Again, you see there was no contract there, they were just talking. Okay, so there's no financial transaction, but it's a position that they were in. An action was brought allegedly that the advice had been given negligently by the respondents. Now, it only failed this case because by chance a disclaimer had been given. Okay, and you can all laugh at me because I have a very large disclaimer into all my things. But that was the only thing that prevented it. And as a result of that, though, it was said in the judgment quite clearly here, if in a sphere where a person is so placed that others could reasonably rely, and that reasonably rely is one of the important parts, reasonably rely on his judgment or on his skill or on his ability to make careful inquiry, such person has taken on himself, we should say herself as well, to give information or advice to, or allow his information or advice to be passed on to another person, who, as he knows or should know, will place reliance on it, then a duty of care will arise. So that's the important bit, okay, and that is something which is followed in you know, as I said. So this is how we ended up with the starting point back in 1964. So that just summarise it, and that's when they extended all professionals' duties of care. Okay. So I think it's you know, this was a very important House of Lords case at the time, and you know, it set out what was a new liability in essence that hadn't existed before. So you can thank the House of Lords Supreme Court as a result of why we've all got the liability that we have. So the result was that this decision had the effect of extending liability for economic loss caused by words. Okay, so this was something which had never been allowed before, and because before it was only by acts you could have economic loss, whereas this you could just say something, somebody loses money, and so it's from statements and acts, and there can be two different types. I'm just going to read another passage in a minute, but there's two different types. Surveyors give facts, statement of fact, and surveyors give opinion. Both of those can be wrong, you know, in some way. As always, I give facts to people. If I quoted this incorrectly, that could be a fact that's incorrectly quoted. In both cases, with facts, you have two bases to it. There's also in the UK the Misrepresentation Act, which I won't go into because it's quite complicated, its applications and changes. And obviously, it's a duty of care at common law as well. For misrepresentation. So when a lawyer actually alleges that you may have given a wrong statement, in fact they will do it in misrepresentation, and they will also do it under common law duty. Now with opinion, all professions have opinions, don't we? The problem is if they're based on the wrong facts, or if you haven't done your research correctly. And you can't be sued for an opinion that is reasonably held, because that's what you formulate, isn't it, your opinion? And therefore you must be very careful of how you formulate your opinions and how you put them down, to make sure it's quite clear that you're satisfied with the method that you come to actually form that opinion, because that is what's criticised, is the formation of the opinion. Okay, so it's the facts behind it. And so when I find it very much like when my first degree, and I say my first degree, was in a science, and we had to support our opinion, and our opinion had to be given on facts that we found through our experiments. And the principle is exactly the same in whatever sphere you are as a professional. If you're going to give an opinion, you have to have the facts behind you. And that's why lawyers write as they do, to state all the central bit that you pay loads of money for, and the opinion at the end or conclusion. So make sure you follow exactly the same format. It's very much like a science project, you follow it through. And if your middle doesn't support your end, I would say after you've written it, read your conclusions or opinions at the end, and then read your middle again and see if it actually supports it. Because some of the time you haven't written the story correctly in the centre to make sure it supports your opinion, and that's when you can be challenged on it. Okay, so always make sure that it follows a story. And also it's easier for the reader, if it's going to go to court or be tempted to be criticised, it will do so in the way it flows, and the fact there could be something contradicting at the end of it. So, reasonable reliance. Again, I think it's probably just easier if I just sort of read out what is normally the view that is given to us when we're trained. The advice is to be given in circumstances in which the reasonable person, and that would be judged on probably what your colleagues would be equivalent of, reasonable person in the defendant's position would appreciate that his advice would be likely to be relied on. Reliance in this area is used in the narrow sense that the words or conduct of the defendant imply undertaking to an identifiable plaintiff, or claimant now, to act in a certain way. And that's what it comes from. Okay. But the one thing that's interesting, because it was what is called the Supreme Court now, it's House of Lords, circumstances may differ infinitely, and there can be no necessary assumption that those features which have served in one case to create the relationship between plaintiff and defendant on which liability depends will necessarily be determined of liability in another case. So that is why when people say, oh, what will the outcome be? It's very difficult, and that still runs true. So that's why I say, and I know it's a bit of a joke putting down, acoustics, but it is like that when we are professionals and we are sued. It is like throwing those sticks over and just seeing what happens and which is going to win the other end, because you're relying on your facts and it takes a long time to go through the process. So that's why, if you appreciate your duty of care, what you should be considering when you're writing the reports or talking to people, or when you should be caveating, and don't be frightened to caveat. I do it frequently, because if you don't, and you said something, and if you're not sure that person has listened, send an email to them and just say, we spoke about, and I want to make it quite clear that this is, such and such, and make sure you do your disclaimer so you've got contemporaneous evidence that you told them on the phone. Because you always get that gut feeling, oh, did they listen to the last bit? So make sure it's quite clear, because that really, really helps with your duty of care to somebody, particularly if you by accident make a general comment. Something which I'll touch on a little bit later is the fact that there was a circumstance that I was aware of where somebody thought they were talking to one particular person in a group in an evening on drinks day, of which they were their client, and somebody overheard the opinion or whatever it was that was given, and that person nearly got sued because somebody relied on it, and the person was slightly inebriated and hadn't realised somebody was listening to them intently, and they had relied on what he'd said because they're being in the same area, and that can cause a problem. So containing the risk, I've just sort of touched on one thing, making sure disclaimers and making sure that you do right back to them. So I say never give opinion as a favour. That really is when things go wrong generally. And I can't stress that enough. Stay professional. In that I mean make sure you put your caveats. And don't give away, even if they're a friend. So don't give away as a friend, still caveat. The more chance of probably being sued by somebody close to you if you're going to do than anything else. Always follow up on conversations in writing, as I've already touched on. That is evidence should anything occur. And also what I said, to stick to your brief, don't go outside it. One of the biggest claims I dealt with was because somebody wrote one line in a one-page document, and it was to do with a very large, which I can't give details about because it was actually set of confidentiality, but it was a very, very large store, where the store opposite only had some cornflakes in, and it was very floating away, what was an old infant site. And the other one had bricks one side and, I don't know, heavy stuff the other side, and it was breaking its back on buns. Now, there was 12 parties to that dispute that I was involved with as a lawyer at the time. And the first sitting, actually, of the judges cost over 100,000, and that was just giving directions as to what party was supposed to do what and when. And there was one party that had been brought in because this chap did a favour. He wrote one sentence outside of his remit. And I think that one settled at something like, I don't know, it was horrendous because it was a loss of income. It was millions. Okay, and they got dragged into it purely because he'd done a favour and he thought he was helping. There's all to do with a calculation on the actual foundations of the building. So that's why I say don't do favours, because it really do come back and bite you generally. Okay, contract. Interesting one. From a commercial perspective, if two commercial entities are negotiating a contract, then the issue isn't too bad. If the other person is very small in the UK, then there can be the unfair contracts terms can be applied. But generally, if you're two large entities agreeing, then that's quite different. If you're dealing with individuals, the question is obviously if you're dealing with individuals perhaps with large yachts, what capacity they're purchasing the yacht in, etc., or whatever they're buying it for. And I know a lot of people here are not necessarily directly involved with yachts, because you're more on the commercial side. But just bear that in mind, it's quite different for individuals buying as in their capacity as individuals. So if you're going to undertake a conditional survey or valuation, you know, this also covers all commercial sides as well. Just make sure that it's clear about the activities. You know, you could have more than one contract with a client. You could have more than one contract, or you can have what's called a collateral contract off of it, depending on what you're doing. It may be that you need to have two types of written contracts because you may be doing two totally different areas where one to modify it might be quite difficult. It depends really on what business activities you're undertaking. But it's always worth trying to have a clause to restrict your total potential loss arising from, I say, providing here evaluation of the audience I was originally targeting, but really the clause to restrict your total potential loss. Now, in many cases, other people will read it and argue so we're not accepting that. But there will come a time where you've got to decide the cost of your insurance, how high you want to go, and whether the job is economical to do at the end of the day. So I think, you know, both sides have to be realistic about it. And here I'll just give an example, actually, limiting liability by removing responsibility for change. And I've used an example of locations, but it doesn't have to be. There could be other changes that you want to mention on a commercial basis. Well, you know, there could be a difference in its value, something's value is worth being in different locations. Limiting or restricting liability because of market forces, again, you should think about that. And here I've actually added something to do with title problems, which probably actually alludes to probably all types of vessels, I would suggest, which can be a problem. And I know it's difficult to restrict your potential liability to a percentage, etc., but it's always worth trying to put a proper restriction in for your own sake. Right. This is an interesting area. I found it fascinating when I studied law because they write books on this one subject, huge books. And it's amazing what the courts have decided, particularly about when people are faxing and they're signing stuff, etc. And then obviously if there was no reference to the law that was to apply or which court they're going to decide, it used to be where the actual contract had been formed, and that's where the acceptance was. So there's a huge amount of litigation on this arguing. So contract is formed with this offer acceptance and consideration. And the funny thing about consideration, which people don't realise, which is money or money's worth, is that there can be a contract form without you realising it. But for example, if I was dealing with one of Jeff now, if I was dealing with Jeff and we had a dispute, and I said to Jeff, for example, if you drop the litigation, if you drop the litigation, we'll pay for our own costs and you won't seek recourse. That's a form of consideration because we're then not going to continue on with litigation. So we formed a contract which can be signed as a consent order, but it has some form of consideration as a contract because I have a potential financial loss by not pursuing for my costs of litigation, or my costs of the litigation. So that forms a contract, and that's a contract to agree to cease, basically, the litigation. So if you want to apply clause, you have to have it incorporated into a contract. And incorporation, again, is interesting now when you've incorporated it. It's interesting because some people don't realise that they haven't actually incorporated their contract or their written terms into the contract to do the job, because they've sent it after somebody's offered and accepted. So for example, if I was offering to do a job and then somebody else accepts and I haven't said, oh, but it's subject to my terms and conditions, and we haven't discussed my terms and conditions, they could have accepted over the phone if they went in. They might write to an email, say, oh yeah, we'll accept it. That can form the contract, if there's sufficient there to form a contract. And then you might say afterwards, actually, no, it's going to be subject to my terms and conditions. Then if you send it afterwards, it's too late. And there's some very good cases on this. So one of them is Shoe Lane Parking, if you want to have a look in the UK where it started from, where they haven't shown the terms before the ticket was purchased. So again, offering acceptance. So be careful and make sure that you get your contracts, your written contracts, and saying incorporated. Yes?
So we send out a quotation to companies of the form. We attach our terms and conditions. They send us back an email saying they accept our quotation. Got with the terms and conditions.
That's fine. Long as it says subject, quotation on the subject to terms and conditions attached.
Right, but then we do the job. Normally, sometimes even after the job's done, we get a purchase order from them, which has their terms and conditions.
Well, no, offer acceptance is they can't impose their terms unless they're referred to them before in an email. If you want to, you can form a contract out of 50, 100 documents, providing you link them. You can start. But I'll give a slightly quick example, but it's making the point. Right, you could have a quotation document that, for example, it could say at the bottom, this quotation is subject to, off the top of my head, it's subject to the email dated content of the email dated 29th of the 10th, 17th, and the document headed up terms and conditions of Shires and such and such. Or alternatively, you could have, let's say, the first one, and in the first one, it could link to the second one by saying, and or the Shire terms could link in there. It could actually have another clause saying, and in addition, included in this, it's such as, so as long as you link them, it's like a rope, you loop them, and one has to refer to the other quite clearly. And the biggest mistake that happens is somebody decides to change their heading. I've seen it so frequently because I do a lot of ports and harbours. They're all rewriting their contracts, and the one that links them all, they've forgotten to change the heading, so you can't tell which one they're talking about. Because they've got a lawyer to write it, because they want those terms and conditions changed for that particular activity, and because that lawyer's just been instructed to do that job, I think you've probably come across it as well. And they didn't know about this linking document, and because probably their knowledge, but they probably should have asked as well, because they need to see the whole flow through. You need to know, and that's just linking them.
But just to be absolutely clear, we send out a quote. with the terms and conditions. And they send us an email saying we accept your quotation.
Well, but what
Then
depends,
it's too late afterwards.
it's offer and acceptance, but it's subject, depends on what they put in their email. If they put, we always undertake and contract in their disclaimer under our own terms and conditions, the question, the argument then comes is whether they put a counter offer in with the terms and conditions. And that's when the argument, that's why
There's something like that, which is we accept your quotation, please go ahead, then they can't change it up.
no, not unless they've discussed it with you. I mean, they might have discussed it with you earlier and say that we've told them. Even entire agreement clauses in contracts are broken, and there's a very good case on there as to whether they are worthwhile now. I always say always put it in there, entire agreement clauses, but contracts and clauses are there to be broken quite frequently by courts. They're tested in court. If you write something different, something that's not tested, then there's a good chance actually that you will, you know, one day it may be tested. But there's lots of clauses in contracts that are not tested. I would say put it in at the end of the day, and then hopefully, you know, you will be able to, well, the courts will allow you to rely on it. But contractually, it's very complicated and it's not straightforward. There are books and books on the subject.
I think if I send out a quotation with some caveats or conditions attached to the quotation,
Yeah.
and the client writes back to say, okay, they are happy with my quotation, and they also stipulates their own condition and ask me to go ahead, I will go ahead.
Well, if you want to
Because
go
as a
ahead,
contract-
then they probably overridden your terms and
Exactly,
conditions.
and
So, because they're forming another, you've got a counter, haven't you?
Yes.
You know, they've said, we'll agree to accept, but we'll only accept it on our own terms.
Then
And then you've got to make a commercial decision whether
Exactly.
you continue. And that is the problem. But always remember that in most cases, if you do that, don't forget your insurance. It's very easy to do. Make sure that you send them a copy of the agreement, because in the rush, if it's a very well-paying job, you might say, "Should I take a flyer on that? I'll do it on theirs." But if you forget before you accept it to have it accepted, you'd have to get retrospectively, you know, retroactive by your insurance. So just make sure that you do that. But it's, you know, commercial. You know, nobody's a robot. I mean, you know, commercially, you do things and think, oh my God, 10 o'clock at night, I've got to tell the insurers. Because it's not at the forefront of, you don't walk around thinking all the time, oh, I must talk to the insurers, I must talk to my insurance broker. In life, it doesn't happen like that. Most of the time, don't panic, go back to a broker and say, you know, we agreed the contract and such, can I have cover for it? This is the terms, can it please be noted? They'll ask you probably that you've had no inference of a claim against you or at all, but you wouldn't have done, as long as you do it before you do the job, you're not going to have a claim against you. So but just make sure you go back and get it noted. Some underwriters may take a different view. I personally, having underwritten as well, don't think that that is a major problem. But again, they may not like the contract you decide to, and then the question is, do you then go with no insurance? If you breach the contract, what is the consequences? Have you caused them a loss? So, you know, that's the problem. The problem you've got is a dilemma. If they don't accept you're doing a job without insurance, potentially. So that's what it is. So always make sure you incorporate what you want. Okay. And I would say also make sure that you keep subjects separate so you can remove them, or a judge can remove them if he doesn't like a bit. So, for example, in the UK, there's the blue pencil philosophy where it's quite clear that a judge can strike out a bit of it and still have the contract making sense. He will strike it out if he doesn't like it. By striking out, we really mean he's not going to take any notice of that sentence. But if you muddle 3 or 4 different aspects in one paragraph or one section, it makes it more difficult for a judge to say, actually, I can just strike that sentence out or the paragraph out and the rest makes sense. So make sure it's quite clear when you write your contracts that everything could be sitting on its own, if that makes sense. If it doesn't make sense, come and talk to me later and I'll try and explain it with some examples. which I can't think of at the moment because I'm on the move, as you might say. So this is just sort of an example. I write and have written a lot of contracts. I write a lot of insurance contracts, and I deal with a lot of insurance disputes on the application of insurance contracts. I also do work for brokers. Although I am a broker myself, I do help other brokers out that know me because they've often made a mistake. That's potentially in place in the business, and there's an argument about paying out of the claim. So I get engaged because I'm known for what I do. But it's interesting because one thing I learned sort of 30 years ago when I started to write contracts is I started to enjoy playing around with changing clauses and the effects and what they do as to whether. And then I discovered that you can change a limitation clause into something else, into some other type of clause. And it almost became a habit of looking at which way we were going to look at this, whether we were going to have a warranty. And I used to write clauses in sort of 3 different ways as a warranty. We could actually have it as a precondition or whatever, so you could do more than that. And by rewording it, you can see the effect. And that came about when the ABI was set, I think it was, started from a personalised point of view, setting out what was warranties, etc. And people were making mistakes. And the biggest one that was made, and it sounds ridiculous now, but insurers were making in the personalised side, which can be obviously considered in other ways, is when an underwriter who had no contractual experience used to write something to do with closing of locks and having locks. This is just so common. This does apply to everything, really. The number of times that I read, I remember in the 80s when somebody had a go at writing a contract, and they wrote something like in the warranty bit, you must have a BS 5076 lock, etc. And that used to come under the warranty section. But the one thing that was missed out was the fact that they should have written basically, without using the word warrant, but you must actually lock the BS 15, whatever it is, lock, between 9 in the evening and 7 in the morning, or you must. So it was just written in the wrong way. They'd put it in, but they hadn't actually made them apply it. So many cases, and that became to court in the 80s, whereby these contracts had been written, but they couldn't apply it. They had the lot, but they didn't have to use it. And and it took insurance a long while for a lot of cases actually, and that was something really basic about the application of having a lock, and then the next process was a warranty to ensure that you actually put it on. But obviously now there's various there's a new insurance act that affects, which I've actually written an article on. I'm going to be wants to go back and actually plug in the IIMS magazine, but everyone wants to go back and read it, but you'll find it there. So this is just sort of one example of a contractual clause. So this is a caveat in the report. But just make sure you're going to caveat as well as have it in your contract. You don't conflict them, i.e. one doesn't contradict the other. So just make sure here the surveyor will not be responsible for any loss arising from a change in market value due to geographical location of the vessel. And the other one is this valuation is based on the value of the vessel at the location as is valued on this report and no other geographical location. So one is quite clearly just carrying it, say what you've done, and the other one is, is contractual. And if you want to put both in, then that's always fine because one clarifies in the report. But just make sure that you don't conflict. Right, contract continued. The contract is formed by offer and acceptance and consideration of, and of course requires incorporation. So it's very important that you remember that and join them up. They should be, and I know I tell people a lot of the time, everything you do as a professional should be like a story. It's got to be attached to each other and it's got to flow. And it's important not only for your clients to understand, but if it comes to court. So that's, so although I'm using the example here of Winnie the Pooh, but it's very, very important that you actually do that. And it makes lawyers' lives a lot easier as well. So many clauses are included in contracts that a court will not uphold in certain circumstances. And but put them in as long as it's clear that they can be taken out. I can't go into consumer law; it's very complicated now, and it's a whole new separate subject, and particularly the UK consumer law, which I could be here all night as well. Right, determining loss and liability and quantum. After a duty is identified, then there has to be a recognised breach of care, followed by causation. I call that a slippery devil because it is causation. It's interesting. I was probably quite lucky because my husband used to work for what was SIS, Solicitors Indemnity Fund, and I used to hear lots of stuff. And they were the mutual that looked after and assured solicitors. And believe it or not, the number of solicitors that miss causation and frequently also didn't start at the beginning. So the one thing I learned over the sort of 12 odd years that my husband was there was always to remember to start at the beginning, always when you review, go back. And the number of times lawyers missed duty of care, the fact there was no duty and they got almost up to court and they skipped basis. It's a bit like, I was attributed to exactly the same thing. How many times do we hear miss the fact we don't check the address on a letter properly? It's so easy, it's the top and the bottom. And it comes in all walks of life, and I realise that with the proportion. So it's instilled in me now that you check at the beginning, because as a lawyer, you don't want to get to court and then find out there was no duty of care and you spent £250,000 for your client. Which was one case actually that gone to court. So it's really, really important. It's so easy to miss. So make sure there is a duty. Breach of duty is slightly easier to define. But causation, I've had arguments many a time with insurance companies that the individuals don't understand causation, that the actual breach has to cause the loss. To me, it's obvious because I'm trained. But particularly when you're dealing with certain insurers, they just don't get it, that one has to cause it. And they say, well, that happened, then it must have done that. I said, no, you've got to do. And that causation is why experts are involved. So that's why you have to write the story. Because that's, it's not just with the, obviously, helping to define whether they might have breached their duty, because you might say, in my opinion, it would normally be done this way. So that will be to whether they've done something correctly. But the other bit is when you come in, it's very important, it's causation, and that is the story. But when we look at causation, we look at what's joining it together. So if you get it in your heads about stories, it's great, because then you can't forget you're writing something which flows. So I've said about causation, I've labelled that probably to death, but it's really, really important. So, causation, and I said it can be a negligent misstatement, and this is just an example. If a vessel is purchased before a client receives a survey report, well, there's no reliance, and going back to that reliance again, it's very important. Did they rely on it? Okay. And reliance is used in lots of jurisdictions. There has to be a connection between the loss and what you did. Not for insurers just to cough up and pay out because you happen to have done something. Many times something has been done incorrectly, but it doesn't mean it caused the loss. And people have breached health and safety, but it doesn't mean it caused the loss. And I've been in many factories where they've breached health and safety, and the claimant solicitor comes, oh, they've breached this, they've breached that. And I say, well, what caused the loss? The fact they haven't got a proper lock on the door didn't stop them slipping. Things like that. So you've got to make sure that there is there's got a connection. And again, with reliability, in terms of statements, that it was actually relied on. Okay. So that's from your point, it has to be actually relied on, or you have to know that it was going to be relied on, or there was a possibility. Otherwise, go back to what I said, heavy burn disclaimer, making sure it's quite clear that other parties are not to rely on. But that can be overridden if somebody says, well, I have to rely on, and then you release it, because it doesn't matter what's in your report, you knowingly have released it for the purposes of being used. Okay, so you then change and modify it, so be careful. Right, determining loss. Sort of lovely argument. There's a very nice case, I'm going to bring it back to on land now, to do with a swimming pool, which was built the wrong size. And it was a very large house, and the argument was whether there should be sort of a diminution in value of the house or to actually repair and replace. Well, the courts decided that the devaluation of this multi-million-pound house wasn't going to be significant enough for this pool to be 2 metres shorter than it should be or something. I can't remember the exact facts, but if you want to look at it, I can find the case for you. And so the question is really about the cost of repair versus diminution of value. The courts are quite reasonable, really, when they take a look at it, because in terms of, from a legal point of view, it should be actually, you're putting somebody back in the position that they should be in, you're not giving them anything better. It's very difficult to do in money terms. And what is reasonable, really? And so they will take a look at that. So if we're saying the costs are unreasonable in all the circumstances, then the measure of damages, i.e. what's paid out, would generally be the devaluation in the value. And that's when it comes with the arguments, particularly when you're dealing with cargo or other stuff, is what other bits and pieces and ships, and what is its value. But this very interesting case, Harrison and others, which I don't think I've got time to go through now. Now, this is interesting. Don't be tempted to go outside your expertise. We have a lot of experts now that are putting fact and opinion and deciding on causation. It's not an expert's area to decide on liability. You are there to tell those that are going to be determining liability, the lawyers, the fact and the opinion, and they put it together and they determine causation, liability. You assist with it, but they may have the final stand. So don't go in the realms of legal side. Firstly, you're stepping outside your professional indemnity. And secondly, it may mean that the judge may decide differently about the content of your report, because you've put something in and they may just strike the whole paragraph out because they don't. I've seen that done when I was at High Court once. So because somebody decided to go into a different area that they were not entitled to because they removed all the validity of that section of the report. It was only a small part, but it was very pertinent. And it depends on whether it's discredited. So to don't go into quasi-legal, make sure you stick to what you expect to find and what your opinion is and how you derived your opinion as your expert, as the expert, whatever you've been asked to do. So, I'm going to time. So this is sort of just an example. It's fair to say the extras tied in XYZ method, which is not commonly found in the UK. And this method has a greater frequency of failure with the ZZZ high tides. I'm just making an example up here. Whereas the lawyer, the barrister, should convert that to as X was tied in such a way, the method which is not commonly found in the UK, and he would evidence that by the expert's report. It has a greater frequency of failure at high tides. Your client should have known. That's when they come in. They point that out. Your client should have known because the facts are what the surveyor has said. So your client should not have allowed X to be tied in. So that's where the lawyer comes in to bring it all together. Right, on to our last bit now. One of my favourite ones, I'm so sorry. It's just writing the day out. Any smiles? Any smiles? Oh, thank you. Right, have an opinion. We're all got a right to have an opinion. Children have loads of opinions. We can talk about it today, actually, loads of opinions. Wrong as it may be, everyone can make an ignorant statement of fact. Okay? We're not perfect, and that's why we've got insurance. And the first mistake you've made is when you think you're perfect. And don't talk more in puffs, walls have ears. So that's one of the main ones. So yeah, it is very important, particularly after a couple of months or more, or 2 o'clock in the morning. Members. General use and information, okay? Might be a little bit, so there we are.
Aaron, thank you very much.